Normally in those days, trials took a couple of hours. In fact, juries were never allowed to separate. No trial took longer than a day. But they came back 3 times to try to encourage him to plead. He refused to plead. What would normally happen in that period, it was a pretty barbaric period, is that those who refused to plead were pressed. They had big stones put on them and pressed to sometimes to death for refusing to plead. That didn't happen to the king, but he was declared guilty, which was the rule that those who refused to plead, even if they withstood the stones on their chest, would be found guilty. What they did then, interestingly enough, was they held a sentencing proceeding in which they heard the evidence against him to satisfy themselves that he was guilty. And that was when John Cooke called his 30 witnesses who had seen the king sort of direct the torture and so forth. So that's quite right.
This is not the main subject, but one offhand remark of yours. You said you wrote letters in 1975. You said you wrote letters in 1975 to Pinochet, and that they were futile. I wonder if you would really maintain that, because many of the human rights organizations who have urgent appeals, they say that these letters do make a difference. Wondering whether you...
I can tell you exactly. I wrote a lot of letters when I joined Amnesty International in the 70s. I used to have to write to Idi Amin, and I'd start, Your Excellency, Idi Amin, VC, DSO, and Bar. He'd awarded himself all these things. I write to ask whether Your Excellency would consider holding an inquest on the 3 Court of Appeal judges who were found floating upside down in the river outside Kampala after delivering a decision that I can well understand Your Excellency might have taken exception to. You write these utterly grovelling letters. And years later, I did submissions for Amnesty International, and I remember going to Venda, which was one of the puppet homelands that the Bantustans that had been set up pretending the South African apartheid regime went through a period of pretending these places were independent, where in fact they were all run by the South Africans. But I met one cabinet minister who was very offended that I came from Amnesty. We get your letters. We get letters galore. We have so many letters from Amnesty. I'll show you the letters we have. Went to a filing cabinet and pulled them all out and emptied them on the desk in front of me. There's all the letters we get about from you Amnesty people at our prison. I actually looked at them and said, but these aren't opened. And they weren't. None of them had been opened. So I'm afraid that is the fate that a lot of those amnesty letters in the 70s and 80s suffered. They perhaps don't suffer the same fate, or perhaps Amnesty have rather strengthened their letters with threats to complain to this or that international prosecutor.
I want to get back to the issue of by what power that you've brought up several times.
Mm-hmm.
In the Eurodia arrest warrants case at the ICJ, it was said that there was jurisdiction over head of state because it was an international. There was no jurisdiction because it was not an international tribunal.
That was Belgium.
Yes. Yes. Then going to your court in Sierra Leone. In the Charles Taylor case, it was said that there was jurisdiction because the special court was an international tribunal.
Right.
And this is where it would seem a little dubious that a court could decide it has its own jurisdiction. And that's where I would suggest, would a court of jurisdiction to decide by what power be a better alternative to a court deciding it has its own jurisdiction?
Yeah, that's a very acute question. You've obviously read rather carefully. Paragraph 61 of the Eurodia case, DRC in Belgium, sets out the 4 rules of when a court has power over a head of state, and I think it's Rule 3 refers to a court which has international jurisdiction vouchsafed by the United Nations. Now that quite clearly applies to the ad hoc tribunals that were set up by the Security Council, the Arusha ICTY and ICTR. My court had to decide whether it applied to what was in fact what is called a hybrid court, in which you had a majority of international judges, but you had a minority of Sierra Leone judges, and set up under a different basis to the ad hoc courts. And obviously it would be more seemly if the decision in relation to each court was taken by another court. But there is no other court, and every tribunal, beginning with the ICTY and the Milosevic challenge, had to decide its own jurisdiction. And there's yet to be a tribunal that's turned down its own jurisdiction. I think under paragraph 61, I've got no difficulty with the ad hoc cases other than Cambodia, which seems to me to be a very dubiously international court. I think it's arguably not, because of course the international judges are in a minority, even though there is the UN connection. But I agree with you, it would be better, but we go as we can under Chapter 7 powers.